I should be recording now. So welcome everyone to the last presentation for intellectual property law for this term. We are in week 11 and we have the lovely Annie, we have Jessica and we have Vanessa presenting for us tonight. And they will be presenting on the leveraging of trademarks. And this is an extraordinarily hot topic. It's one that is burning, not just in terms of our own local trademark scene, which is where this particular presentation is set. But trademark leveraging is really a global phenomenon. And I won't say too much about it because I don't want to preempt anything that the group members have to say. But they have been tasked with providing a memorandum to the product development team for the development of some products. I'll leave it to the group. I believe it was going to be one particular product. Is that right?
That's correct.
So they've been tasked with providing a memorandum to the product development team for some guidelines to assist the PD team when they are looking at marketing a new product. And the aim is to try as much as this particular company can, looks like Aldi, to leverage from existing brand equity as much as they can without running afoul of trademark law or other nasties. So without further ado, I will hand it over to you guys. Who would you like me to hand over to?
I'll be starting us off today.
Excellent. Thanks, Jessica. You can start your presentation.
Okay. Lovely. Can you see my screen?
Yes.
Okay. So hi AJ, fellow classmates, and those of you watching this recording on YouTube. Welcome to the Week 11 presentation. I'm Jess, and together with Annie and Vanessa, we're going to talk to you about leveraging trademarks. So our task for this week was to act as the legal advisors to a product development team that are launching a new product. The product development team want to launch the product into the market by leveraging existing brand identities. Our task was to provide a report highlighting the merits of this approach and to evaluate the potential legal risks involved. For our report, we're advising Aldi on leveraging the Dove brand in order to launch their new product. For this workshop, we have selected 3 Dove products in order to discuss the connections between brand identity and intellectual property. Aldi is well known for selling copycat generic branded products. Famously, Aldi's catchphrase is "like brands, only cheaper." There are a number of reasons why consumers will purchase copycat generic branded products. The first is cost. Some consumers simply cannot afford to purchase the branded products, while others are simply trying to save money. Second is comparison. Consumers will purchase a lookalike product to see if it is as good as the branded product. And third, sometimes it's just by mistake. Some consumers may have purchased the lookalike product thinking that it was actually the branded product. The key aspect of product leveraging is to invoke a sense of quality, trust, and instant recognition in your product without tipping the scales and leading into deception or infringement. In leveraging a product, Aldi needs to ensure that its customers are under no illusions as to what they are buying to ensure their customers are not being misled. For this workshop, I will give an overview of trademarks, trade dress, and product leveraging. I will then discuss how these factors relate to the various Dove products we have selected in order to advise the product development team. Annie will then discuss the legal risks and implications associated with leveraging trademarks. And finally, Vanessa will discuss our recommendations to Aldi, including what aspects of Dove's brand may be leveraged with relevance to relevant risk analysis. In addition, she will discuss any alternative areas of law Aldi needs to be conscious of. So first things first, what is a trademark? A trademark is a way of identifying a unique product or service, sometimes referred to as a brand. Trademarks can help customers discern the quality of your product or service over that of their competition. Trademarks serve a variety of functions, including a badge of origin, guarantee of quality, a means of differentiating a product or service, and as an advertising tool. Section 17 of the Trademark Act defines a trademark as a sign used or intended to be used to distinguish goods or services dealt with or provided in the course of trade by a person from goods or services so dealt with or provided by any other person. The definition of a sign is found in Section 6 of the Act, which states the sign includes the following or any combination of the following, namely any letter, word, name, signature, numeral, device, brand, heading, label, ticket, aspect of packaging, shape, colour, sound, or scent. Sources of applicable trademark law in Australia include the Trademarks Act 1995, Trademarks Regulations 1995, the common law through the tort of passing off, and international obligations and bilateral treaties such as the TRIPS Agreement. Further, wrongful acts involving trademarks can lead to an action in misleading and deceptive conduct under Section 18 of the Australian Consumer Law. The proprietor of a registered trademark has exclusive rights to use that mark in relation to goods or services with respect to which it is registered. Further, the owner of the registered mark has the right to obtain a relief under the Act if the trademark has been infringed. It is important to note, however, that trademark registration is not for the sign itself. Registration is for the sign as used in a particular class of goods or services according to the NIS classification system. In our case, relevant Dove trademarks are registered in Class 3. The definition of Class 3 is bleaching preparations and other substances for laundry use, including cleaning, polishing, scouring, and abrasive preparations, non-medicated soaps and perfumery, essential oils, non-medicated cosmetics, non-medicated hair lotions, and non-medicated dentifrice. Trademarks must be actively used or they may be removed for non-use. Trademark registration lasts for 10 years from its filing date. However, trademarks can be renewed indefinitely, provided the renewal fees are paid. In order to be registered, trademarks must be represented graphically. As the primary function of a trademark is its use as a badge of origin, the heart of trademark registration lies in the mark's ability to distinguish the goods or services of one trader from those of another. Trademarks are becoming increasingly important in advertising and marketing since the public has become to associate certain image, quality, or reputation with goods or services bearing a particular trademark. So trademarks can be logos, words, and slogans. A trademark may be composed of a number of words, including phrases, mottos, epigrams, proverbs, and adages. Trademarks of this type are categorised as slogans. A trademark may be a logo, a business name, or a slogan used in advertising. As with all forms of trademark, it must be capable of distinguishing the product or service. As you can see on the slide, a number of trademark examples, including the Apple logo, the Qantas logo, brand and slogan, the Spirit of Australia, and one of AJ's favourite slogans, McDonald's, I'm loving it. As a point of interest, the product PEP featured on the slide, it's basically a cough lolly, was the first federally registered trademark in Australia. This comes to colours. So a specific colour can function as a trademark. However, the process of registering a colour is not easy. Colour trademarks need to be supported by significant evidence of use to achieve registration. In order for registration to be successful, you must show that the public has come to identify the colour with your particular goods or services. This means that the company needs to be using the colour as a badge of origin rather than just a simple decoration. There are many trademark colours that are instantly recognisable, and I've prepared a little mini quiz for you all. So if you were to see this colour, you would know that the brand was Tiffany & Co. Or if you were to see this one, you would know that it was McDonald's. This one, I'm sure as students, we've all had this product to get through those long study sessions. Is of course Cadbury. And finally, another one I'm sure quite familiar to students is Starbucks. One important thing to note is that trademarking a colour does not grant ownership in that colour. For example, you could not create a jewellery store and use the Tiffany blue colour. However, you could use the Tiffany blue colour for a completely unrelated business such as a cafe. So sounds. A sound trademark can be anything auditory, ranging from a complex orchestral fanfare to a simple clicking noise. It can be sung or spoken words or a combination of voice and other sounds. Whatever the sound, it must serve the purpose of distinguishing the goods or services of the supplier. Some examples of sound trademarks include and my personal favourite, and it is, of course, Vegemite. So scents. A scent can be scent trademark is a distinctive smell used to distinguish goods or services. However, it cannot just be the scent itself in isolation. To qualify as a trademark, the scent must be an unusual or distinctive smell that is associated with a particular item, product, or provision of a service. Again, like any other trademark, for a scent to be registerable, it must be represented graphically by way of concise written description of the scent and how it will be applied. There is only one registered scent mark in Australia, and that is the Eucalyptus radiata scent applied to golf tees. Interestingly, as I fell down the trademark rabbit hole during my research, I discovered that Hasbro has filed an application for trademark registration in the US for Play-Doh. It describes Play-Doh's particular smell as a unique scent formed through the combination of a sweet, slightly musky, vanilla-like fragrance with slight overtones of cherry and the natural smell of salted wheat-based dough.
Which kids love to eat?
Yes. Another element of goods or services is what's known as trade dress. Trade dress is a legal term of art that generally refers to the characteristics and visual appearance of a product or its packaging that signify the source of the product to consumers. Trade dress is a broad term covering distinctive non-functional elements of packaging or design, which promotes the product and distinguishes one trader's goods or services from those of another. In some cases, it may be a single element, such as the colour or shape of packaging or containers, the configuration or arrangement of elements, through to the total image concept. Trade dress can be protected under trademark law if it can be shown that the average consumer would likely be confused as to the product origin if another product were allowed to appear in a similar dress. So this brings me to leveraging. Leveraging is a commercial practice of exploiting advantages of either your own brand or vicariously benefiting from others. In the marketing field, this means attaching a product to positive brand associations and imagery. We can see from the examples on the slide that leveraging brand identities is a common strategy among businesses that sell own brand products such as Audi. In each of these images, it's pretty evident that the two products are very similar, from the colours and images used to the shape of the bottles. The issue that needs to be addressed when considering leveraging brand identities is the generic brand simply using the trade dress of the branded products in order to leverage their brand identity? Or is the product sailing too close to the wind and potentially causing deception or infringing a trademark? So how does this all apply to our advice to Audi's product development team? Dove have a vast suite of products, each with slight variances in applicable trademarks. For the purposes of our advice, we have considered these three products: a body wash, a roll-on, and an aerosol deodorant. Common amongst all three products is the trademark for the Dove name and logo. Both the body wash and the aerosol deodorant bear the trademark Go Fresh. The roll-on bears the trademark 1 quarter moisturising cream. Although interestingly, it appears as only the words 1 quarter moisturising are trademarked and not the shortened teardrop shape that 1 quarter appears in. Finally, the body wash bears the trademark Nutrient Moisture. The use of any of these would be a clear trademark infringement. However, there are a number of other aspects to the packaging or trade dress that Audi may use in order to leverage their product. These include the imagery on the packaging that signify the scent of the product, the colour of the packaging from the white bottles to the different coloured caps, the shape of the bottles, and finally the fonts used and the placement of text and images, all of which contribute to the overall visual appearance of the product. I will now hand over to Annie, who will discuss the legal risks and implications associated with leveraging trademarks.
Thanks, Jess. So brand leveraging, as Jess said, is an important form of new product introduction. It provides consumers with a sense of familiarity by carrying positive brand characteristics and attitudes into a new product category. Instant recognition of the brand is established, and consumers with a favourable brand opinion likely will try a new product they perceive to have a similar quality, level and attributes as their original favourite. However, while brand leveraging can be a successful marketing introduction of your product, there are legal risks involved if done incorrectly. So before we present recommendations, I'll discuss the legal risks you need to be aware of. Okay. Passing off. The tort of passing off is a tort or a civil infringement of right, where one person, business, or a company presents itself and its products to the market in a manner that is similar or identical to another person, business, or company, and in doing so creates confusion in the mind of the market. In determining passing off claims, the courts will have to consider evidence of your presence in the geographical area and the length of time you've conducted your business. The modern tort of passing off extends to include more than just the protection of a product or business name. It includes images associated with the goods and services, the colour, and the get-up or packing of the goods. The tort of passing off applies to different situations in which there is damage to the business reputation as the result of a misrepresentation in relation to the supply of another business's products or services. Some examples of passing off include a misrepresentation that one person's goods are those of another, a misrepresentation that one person's goods are of a particular class or quality, a misrepresentation that a connection exists between a person's goods and those of another where there is no actual connection, using images or representations of a character or person to suggest an endorsement or a connection between that person or character with the goods where there is no actual connection or endorsement. Essentially, you need to make sure you are aware passing off actions involve situations in which a representation is made in the course of trade, which deceives or causes confusion amongst customers either online or in the real world. In the case of Irving Warnick v. J. Townend and Sons, Warnick was one of the primary market producers as a Dutch liqueur made up of a blend of hen egg yolks, aromatic spirits, sugar, brandy, in which it sold under the name Advocate. Townend produced a similar alcoholic drink using egg and cypress wine and sold it as Keeling Old English Advocate. The court held in this case that Townend was passing off their goods as those of Warnick. In applying the test for passing off, the court developed what is known as the extended passing off, which included any situation where goodwill is likely to be injured by a misrepresentation. Lord Diplock established 5 elements for a claim of passing off, which you'll need to make yourself familiar with the following criteria. Does the product have the ability to misrepresent a reasonable consumer? Has the misrepresentation been made by you as the trader in the course of trade? Sorry, just one slide behind here. Here we are. Has the misrepresentation been made to prospective consumers, which is calculated to injure the business or goodwill of another trader in which you have leveraged off? And has this caused actual damages to the business or goodwill of the trader bringing the action? When leveraging off another brand, another risk to be aware of is trademark infringement. Trademarks and reputation are a valuable component of a company's IP portfolio. By considering ways to leverage these important IP assets, a company can increase its revenue and the reach of its brand in the marketplace. But with so many legal issues at stake, you need to make these decisions with great care. Under Section 120 of the Trademarks Act, a person infringes a registered trademark if that person uses a trademark sign that is substantially identical with or deceptively similar to the trademark in relation to the goods or services in respect of which the trademark is registered, which I have previously explained to you. In considering whether consumers are likely to be misled or deceived for the purposes of Section 18 of the Australian Consumer Law, it is necessary to consider all surrounding circumstances. An amusing example for you is the case of Louis Vuitton against the South Korean restaurant Louis Vuitton Dak. Essentially what happened is that a restaurant in Seoul upset Louis Vuitton by taking its name and monogram pattern to sell chicken. It is known that Louis Vuitton Dak adopted the name, at least in part due to the fun factor, as the last two words read together, Tong Dak, is the Korean word for whole chicken. Louis Vuitton Dak was contacted by a court in Seoul and threatened with large fines. The owner changed the name to Cha Louis V. Ton Dak, as seen on the screen. And this was a big mistake. And he finally ended up paying a fine of 14.5 million Korean won, which is about $125,000. In the event that a registered trademark is infringed, the relief available against you is an injunction and, at the option of the applicant, compensatory damages or an account of profits for additional damages. And in the event that passing off is established, the relief available against you would include an injunction and the option of at the option of the applicant, compensatory damages or an account for profits made by your product. So you need to make sure that you're aware of all these legal risks before going ahead. I'll now pass you to Vanessa for our recommendations.
Hi everyone, Jess and Annie have taken you through what a trademark is, the rights associated with the registered trademark, the benefits of leveraging, and also the civil tort action of passing off. I'm going to take you through some recommendations on what aspects of Dove's brand can be leveraged, provide a risk analysis in respect of those recommendations, and finally, considering the Australian Consumer Law, or ACL, and its potential concerns on leveraging. So if we have a look at my first slide, I've included two graphics available in the public domain which provide useful analysis on the Dove brand itself, the various dimensions of the product or product lines, marketing campaigns, but also the value of the brand, which we are seeking to exploit. I'm sure many of you have tried Dove products in the past and perhaps seen their social media campaigns. To effectively leverage, we first need to dig deeper and consider what are the relevant features of Dove's get-up or trade dress that make their products look and feel like Dove. What are the features that are unique to Dove or common to the market more broadly? So if we have a look at the first bottle, this is Dove's complete get-up for their lead body wash. By that I mean their traditional triple moisturising, deeply nourishing body wash, which features the Nutrient Moisture trademark logo, which Jess mentioned earlier. You can see in the remaining two images, I've removed the logo of the Dove, and finally, I've removed the word Dove. But despite removing the word and the logo, you'd still be likely to recognise that these are Dove products because of the unique colour scheme and because you're viewing this particular product in isolation from its competitors. If we have a look at Dove's, sorry, I'm not sure why that's played again. Okay. If we have a look at Dove's body wash, deodorant in the roll-on form or aerosol can, there are commonalities between the products. They are all matte white, they have Dove written in prominent and distinctive blue script, and they all feature a gold Dove. The body wash and deodorant in the aerosol can each feature a piece of fruit to signify the scent with matching coloured lids or dispensing nozzles. The get-up of the roll-on deodorant is dominated by white and features a navy lid. Despite the dissimilarities, you still get the feeling that these products are related to the same brand and family. It would be too simplistic, not to mention an obvious infringement of a registered trademark, to reproduce an exact copy of Dove's get-up as depicted in these photos. This doesn't mean it's impossible to leverage against Dove, it just means that you need to be more creative. So I'm just going to provide some general preliminary advice. And the first is that it's advisable that the actual product itself resembles that of Dove. So this would mean milk and white and milky products. Although get-up refers to the external, we want to be drawing parallels where we can. Dove's products are well known for their apparent use of 1/4 moisturising cream. What is less well known is that not all of their products include 1/4 moisturising cream, including some of their body wash, moisturiser and hair care products. We recommend the body wash and roll-on deodorant incorporate some content of moisturising cream, which will assist in the overall placement of the product and allow an argument to be made that any references to moisturising cream can be substantiated should Dove bring any legal actions. I've put marketing campaign on the slide, and you may be wondering why, considering leveraging centres more on the get-up itself. I think Dove's marketing campaign exceeds more than just the product and taps into something that is less about commerciality and more about self-empowerment. And it's actually meant that Dove has shifted from being brand-driven to purpose-driven. The advertising campaigns conducted by Dove infect customers with inspirational and empowering emotions such as positive body image ideals, embracing and diversity, and self-acceptance. Their campaigns often include women of various racial backgrounds and body types, and one current campaign includes the slogan, "You're more beautiful than you think." The aspirations of Dove's campaigns translate into greater sales and market share because the decision to purchase exceeds the choice to simply purchase deodorant or body wash. Rather, it is a feel-good purchase that makes you feel like you belong to a community. And this brings me to our recommendations. So the first recommendation is to focus on commonalities within the market. This strategy involves incorporating features of GetUp that are common not only to Dove, but also its competitors. So for example, if we look at Dove's competitors in the body wash market, you can see that Palmolive, Radox and Dettol have all adopted similar packaging. White bottles, coloured fruit reflective of the scent or included extracts, and fairly similar shaped bottles. Given the similarities between the designs, a customer is more likely to be astute and discerning when reaching for their usual brand of choice. It follows that this will not be a particularly effective strategy beyond that on the plus side, it carries very little risk. It would be difficult for Dove or any brand to bring in action for passing off, for example, if the GetUp shares characteristics that are common within the market. Our second recommendation is to focus on the name. So the name of a product can be critical in developing a profile and brand awareness. The word Dove is obviously trademarked and recognizable, not only for the use of a bird emblematic of peace, but also purity. In combination with the colour white, it also implies cleanliness, clarity, and efficiency when applied to personal hygiene products. Dove's logo is represented not only by the word Dove, but also a typical depiction of a dove in gold. We suggest the following names: Love, which may be written with a similar font to Dove and may use the logo of a gold heart. The other suggestion may be the word Swan, with the gold swan as a symbol. Other names may be suitable, but these were chosen for their length, that is that there are only 4 letters, the similarity of font when in print, and suitability for the products themselves. Having said the above, the name of the product on its own is not going to bring much reward. This is only going to be effective if the font, the logo, and the packaging are similar to that of Dove. The name on its own is going to carry little risk, but also little reward. It is the get-up of the name and logo which will leverage against Dove. Some consumers may even appreciate the humour in naming the product Swan as opposed to Dove. This takes me to our next recommendation, which is on the slogan. Dove has trademarked the name of some of its products, but also Dove one quarter moisturising cream. We've already mentioned Dove utilises moisturising cream in some of its products, and there may be a catchy slogan or wrangle that can be used there. One of our suggestions may be to start with a joke. For example, why did the dove cross the road? Because all you need is love/swan/insert product name here. Now, this corny joke is actually a play on an actual campaign by a Dove, All You Need Is Love, in addition to being famous lyrics by the Beatles. This particular slogan, whilst obviously a bit cheeky and very cheesy, does not infringe upon Dove's trademarks because arguably the use of the word Dove in the sense of the question is generic, and the question is a twist on age-old dad-style humour asking why a chicken crossed the road. The answer to the question is a play on the Dove campaign, but instead relies on our product name and not that of Dove as the answer. Alternatively, there are very cheesy slogans like smell like a flower, take a shower, and say no to BO. Clearly, witty one-liners are not my forte, but there is plenty of scope once the products have been developed to come up with something, and perhaps a reference to current pop culture may assist. We would recommend against using slogans that negatively portray Dove, such as like Dove, but better, because this is essentially an unsubstantiated statement which takes us down the path of comparative advertising and away from strictly leveraging. A slogan will assist in a marketing campaign when launching the new products and may be effective if it can gain traction in social media. We would suggest a white background, navy script, and the gold logo feature prominently, reflective of similar Dove ad campaigns. Our fourth and final recommendation is to perhaps use or tailor a lapsed trademark. There are a number of trademark Dove logos in Australia, but not all of them have been renewed, and the 3 that are depicted have since lapsed. As you can see from the dates on the slide, these are well outside the 6-month grace period that is pursuant to Section 78 of the Trademark Act. So these pictures themselves are unique because they're the original drawings they have on there, what date that these trademarks were accepted, registered and renewed, but it also has on there the due dates of when they should have been renewed. The fact that these trademarks have since lapsed means that they are technically free for use. The risk, of course, is that they're still clearly associated with Dove, both in word and in imagery, not to mention that they were trademarked by Dove. These logos are indicative of times past, and they also look relatively dated. The question is how far these could be adapted to reflect Love or Swan, but distant enough to be a carbon copy of these former trademark logos. This strategy may be effective in part, but it's also very high risk. The intention to replicate an exact Dove logo will readily be established, and by extension, an intention to deceive customers, which I will cover shortly. The question of risk really turns on how true you can remain to the original image and retain its look and feel, but also distant enough to make it a new logo. You're essentially seeking to capitalise on a former trademark in the hope that it evokes nostalgia. This would not be our recommended trademark. In summary of our recommendations, it is likely to be a combination of each of our recommendations that is likely to be the most effective. After all, get-up of a product is not centred exclusively on the name, the logo, slogan or colour. It is the sum of these moving parts that produces, in our case, attempts to reproduce the look and feel of a brand and its product. This leads me to challenges and an alternative area of law. Depending on the implementation, we do not anticipate challenges from new competitors or old. Any challenges are likely to arise from Dove, who will undoubtedly seek to protect their brand, registered trademarks and market share. The risk of a challenge is really going to depend on the degree of implementation by Aldi of our recommendations and how close it comes to the line of those registered trademarks by Dove. Beyond infringing trademarks or civil actions for passing off, it is also pertinent to consider whether the Anti-Competition and Consumer Commission, the ACCC, may be concerned by Aldi's efforts to leverage against Dove. Related to passing off and trademark infringement is the Australian Consumer Law, which Annie referred to earlier. Section 18 within Schedule 2 of the Competition and Consumer Act, the ACL in other words, is a general prohibition on certain conduct. If we look at the section itself, it says a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or is likely to mislead or deceive. The first part of this section requires the conduct to occur within the practice of trade and commerce, so it can't be a statement made at a Sunday barbecue. In this instance, it's going to be relatively straightforward. These products will be rolled into Aldi stores for sale and purchase for consumers, satisfying this requirement. The second and third parts to this section sound very similar, but require analysis of different perspectives by considering objectively all relevant circumstances constituted by acts, omissions, statements, or silence. The court must decide whether conduct is or is likely to be misleading or deceptive. A court will likely conclude conduct is misleading or deceptive if it leads into error. You can see that this is a relatively low standard to establish. It would seem intention plays a significant role in assisting a court to determine whether the conduct was misleading or deceptive. The full federal court has previously held that where a trader, having knowledge of a particular market, borrows aspects of a competitor's get-up, it is a reasonable inference that he or she believes there will be a market benefit in doing so. It is therefore an available inference that the trader considered such borrowing was fitted for the purpose and therefore likely to deceive or confuse. Contraventions under Section 18 also require consideration of the effect of the misleading or deceptive conduct on ordinary or reasonable members of the classes of prospective purchasers. Aldi retains a niche position within the Australian retail landscape and may not be seeking to obtain a large market share. However, leveraging represents a relatively easy way to launch a new brand or product. Brand awareness usually leads to greater sales and market share. It is easy to understand why many newcomers would want to jump in and stand in the light of a more established brand, one recognised for quality, consistency, and premium brand standing. This must be balanced against the freedom of competition, but also the protection of consumers and companies alike. While it may be legally sound, there are many aspects of leveraging that really skirt around what is ethically right or wrong, and exploitation is at the heart of the initiative. On behalf of Jess, Annie, and myself, we want to thank you for your attendance, and we'll leave it now in AJ's hands.
Excellent work. Excellent work. Thank you very much for that very informative presentation. That was great. I want to just spend a little bit of time now going through your presentation. I've made the usual copious notes here. So what I will do is I will pause the recording here and I will just chat to you guys informally. So thank you to everyone else who's watched the video on YouTube. If you have any queries or questions, as always, just drop me an email. Otherwise, I'll chat to you hopefully in next week's Zoom session. And I will end it here. Thank you very much.